therein these facts, and under bona fide misconception the permission has been accorded, the FIR was registered. But since it is not in consonance with the decision of the Honorable Apex Court, so therefore, my lords, the FIR may be permitted to be withdrawn with liberty, my lords, to move the Honorable Court again for fresh. If that will be given, then well and good. So this petition, my lord, if I will see, and my lords will permit me, then on that basis, my lords, otherwise, because of that other, because even in that Delhi's case, my lords, it was pointed out that when once FIR is registered, it can't be rescinded. That's why I am saying that I will indicate that, but I will file an application, my lords, within 2 days. By Monday.
You see, the difficulty is that it's the not only judiciary, but your entire legal fraternity suffers. Today a case came before me, that is, there was some scuffle between the lawyers and immediately police registered a FIR. There are 100 methods. First they could have made them sit together.
Yeah.
They are all arms of law. They are officers of the court.
Yeah.
And instead of doing that, you immediately register FIR. It has become so oppressive that one finds difficult to normally transact any business. Now, as far as your second submission is concerned, well, there is a ground for withdrawal of FIR, which is known as error of law. So, what you have said just now, that in misconception that is possible. There is that is, you will find some judgment also, some precedent also, that is called error of law. So if some FIR has been registered as an error of law, you can always withdraw it. But where do you intend to move that application? Before the magistrate where you have sent your 154 report?
Because, Lords, in fact, because that, Lords, that, or I think it would be better if that application is filed before my Lord. Because here, my Lords, I can, and this all happened, Lords, that of this communication, my Lords, from the learned Registrar General to learned District Session Judge and copied to SP, that we thought it that when it is mentioned there, so if permission has been accorded. So under that misconception, otherwise, my lords, there was no occasion for the learned district judge to have sent that letter, because earlier the learned session judge has forwarded our request for permission to the learned Registrar General.
No, we don't want to get into all this.
No, therefore, my lords, that was, I see, that was the bona fide reason of misconception ki permission has been accorded. Not that intentionally, my lords, the police...
You see, it would have been a different matter had it been some private dispute. Here, the police is going into his chamber. His chamber is part of his court. The chamber of...
Yes. Lords, there can't be any dispute.
Chamber of my chamber or brother's chamber.
That is part of.
We have been hearing matters there also.
Yes, Lords, there can't
or
be.
if you consider it a public place,
No.
well...
Yeah, Lord, this fraternity, and there can't be any compromise in that. Yes, I say ki because of that circumstances, Lords, had not we received the communication from the learned registrar indicating that if the authorities are competent to proceed ahead, Lords, we would not have touched that.
Even if that communication is taken into consideration, it said proceed as per law.
Yeah.
So law
So,
is here.
Lords, again I say,
You
Lords, I am not making any
proceeded
excuse.
against law.
Yeah, Lords, the law, because under that impression that I have to seek prior permission, the SHO Lords wrote a letter seeking permission and forwarded the letter to the learned registrar, district and session judge. Learned district and session judge forwarded that communication to the learned registrar general. Now the learned district and session judge, after a month, with reference to the letter by which that permission letter had been forwarded to him by
See,
the
now-
superintendent of police.
Now the resultant effect would be
Yeah.
any litigant who is disgruntled with the order of the judicial officer will file FIR. Thousands of FIR will be filed
No,
against all the judicial officers.
No, I am saying, Lords, I am adhering to that law. Of
So, no, what
the-
I am saying is this tendency is very dangerous. It will lead to complication and lodging of several FIRs
No, therefore,
against,
Lords,
against all the judicial
No,
officers.
Lords, it should be strictly adhered to.
Therefore, you do the needful. Will
Yes, therefore I say ki,
Why Supreme Court has laid down this law? In Veera Swamy, in UP Judicial Officer, in T. Sazari, all these cases.
yeah,
Because if these judicial officers are subjected to FIR, the very democratic institution will be in
Lords, yeah.
danger.
Lords, there can't be two opinion about it. All the time what I am repeating, that because of this change, Lords, we were under the bona fide impression that as required and laid down by the Honorable Apex Court, the communication from the Registrar General is communication of the permission. But still I am not going behind. I am still not
So,
going behind that.
Certain authorities, like High Court judges, they are constitutional authorities.
But yeah,
Even-
but I am not
even-
harping on that.
Even
I'm-
Advocate General,
Yes, he is a
Is
part
a-
of that. He is a part of that. Tomorrow we will say
I think
a
you
lot
can,
of
you-
people from different varieties. Lords used to come and Lord, some are coming with some grievances with respect to pendency of matter, either with
you can
my
address,
office or
you can
the
address both our houses of the Vidhan Sabha and Vidhan Parishad
yeah.
as Advocate General.
Yeah, my lords, only not that. I'm also conscious, of course, not in there, but why it was being debated in the before the Constituent Assembly, my lords, a proposal had been that Advocate General should be the Minister of Justice, because that is being there in
Okay,
that. So
can you-
I'm conscious of that also. That even if, my lords, I may not, I may be holding only the status of a cabinet minister, but still, my lords, I consider to be that. Therefore, taking into account, my lord, I will be the.
So
I
if
tell-
if they make a beginning somewhere,
so,
you don't know where it will end up.
yeah. Therefore, my lords, I am conscious, and I will be the last person to have it in any effect, my lords, impair or prejudice the majesty. Therefore, my lords, I say we will file a petition within 2 days, by Monday or.
All right.
My lord, if my lords would like to have a look at section 321 of the CRPC.
That is for withdrawal of prosecution. Prosecution starts till date. No
That is
prosecution has started.
321 is a separate provision.
My lord,
That is during the course of trial.
my lord, prosecution it
So
says.
prosecution, FIR is
Prosecution
pending.
is not yet started.
Not has started.
It is a FIR.
Once it comes before the,
No, that has already been defined in catenas of when prosecution starts. It's only after submission of the charge sheet and then
No,
cognizance is
but
taken, then.
after FIR, there is no prosecution. It is investigation. You see,
my lord,
after investigation, they can always file a closure report.
my lord,
If there is a closure report, there can't be any prosecution.
I was just drawing my lord's
So
attention.
therefore, they are in a bind.
My lord.
They are in a bind because they don't know how to withdraw FIR.
That is a kind of presenting a fait accompli to the court, my lord.
No. You will just see.